Check, 1, 2. Better? What? So the judge is already starting to cause trouble. Yes, welcome everyone. Welcome. Are we good to go and are we live? I can't see anyone right now, so you're going to have to, yes, I think Matt back there. Okay, so, ready? 3, 2, 1, here we go. Welcome everyone. On behalf of the HF Langenberg Speaker Series and Hammond Institute for Free Enterprise at Lindenwood University, ISIT.org, Free to Choose Network, Stossel in the Classroom, and News Talk St. Louis, I thank you for joining us on site or online. We are honored that over 300 people have joined our conversation about the United States Constitution and the challenges it faces in modern times. The esteemed Judge Douglas H. Ginsburg and our riveting discussion leader, Howard Wall, promised to make this event a memorable one. We hope you keep this conversation going. Let me introduce myself. I am Tawny Hunt Ferrarini, the R.W. Plaster Professor of Economic Education at Lindenwood University, and I serve as the Director of the Economic Education Center. I am your MC. Tonight, we have the privilege of hosting U.S. Court of Appeals Federal Judge Douglas H. Ginsburg as our featured speaker. Judge Ginsburg will deliver a thought-provoking talk on the importance of educating ourselves and others about the U.S. Constitution and its relevance in today's society. He will share expert insights on contemporary movements to change the Constitution, highlighting the potential trade-offs individuals may face if government control and political influence are expanded. Following the judge's talk, we will have a dynamic conversation with Howard Wall taking the lead. He will use his economic expertise and academic research to engage the judge. Dr. Wall will raise some hard questions submitted by you, the registered participants, fostering interactive and civil discourse. We encourage you to share your thoughts on social media using hashtag Hammond Institute and hashtag US Constitution as we aim to create a dynamic session. After the conversation concludes, we will express our gratitude once again to our sponsors and supporters. We'll provide you with an abundance of information on how to keep the conversation going, how to access extensive resources available from tonight's co-sponsors, ISIT, Free to Choose, Stossel in the Classroom, and stay connected through Lindenwood, through the Hammond Institute, and of course, News Talk St. Louis. A moment of gratitude. I want to sincerely thank you on behalf of the Hammond Institute for joining us. We are growing individuals seeking the truth about what makes humans flourish. Tonight, we have VIP guests and special educational leaders from the East Coast who have come together in the greater St. Louis region. Yes, we even have the great-great-granddaughter of Dred Scott in our audience. For our online viewers who are unfamiliar with Lindenwood University, it's a university committed to providing real experience and real success education. It is home to over 7,000 students situated in the historic St. Charles area. It's in Missouri. We're located west of the Missouri River, and as some like to say, west of the Mississippi River. Now let's move forward with our core program. It is with great pleasure that I bring our esteemed speaker and guests onto the stage. Can you please come and join us? Okay, and as we welcome him, if you want more information about the judge, please check out his bio online, and it's in numerous places. So thank you, Judge.
Thank you. Thank you for that lovely introduction. Don't believe all those things you read online. I don't think this is live. Am I wrong? No, you're correct. Oh, actually, pardon me, this is live. Correct? Can I be heard and back? Great, thank you. Well, I want to thank Tawny, Lindenwood, all the people that made this possible tonight, and the several, I'd say actually many, friends of my wife and me who are from St. Louis, as is my wife, and who came out this evening. So appreciate seeing you all again, and meeting some new people as well. I'm going to be brief because the primary way of eliciting information from me, or opinions or what have you, is going to be by forcing them out with probing questions. So I'm going to say only a few things before we begin that. The Constitution was written in order to be submitted to the people. There were 2.5 million people in the United States then, for ratification. And it had to be written in a way that could be understood by I wouldn't say the average person, but certainly anybody who was qualified to vote at that time, which would mean white men, and most of them, many of them, and probably most educated. Educated in John Locke's treatise on government, educated in the Old and New Testaments, and a variety of other sources that were common to the American culture of the time, and common sense, that 47-page, I think it is, pamphlet by Thomas Paine that sold tens of thousands of copies immediately after being published in 1776. So it is meant to be read and understood by people like yourselves. And I'm not sure, I don't think I'll ask how many of you have actually read the Constitution, or maybe read it in the last, since college, let's say, maybe even in college. But it bears reading. There's a lot there that is maybe a surprise. Some of the details, some of them might make you wonder how we got where we are with the limitations seemingly imposed by the Constitution on the power of the federal government, which has consistently slipped the bonds with the approval ultimately of the Supreme Court. So I guess one way of putting it all is that if you're buying a home or selling a home, you're probably going to need a lawyer to do it. But you don't need a lawyer to read the Constitution, and you don't have to be a lawyer to read the Constitution. And a lot of lawyers have read it for a long time, and that's somehow part of how we ended up here, where we are. Anyway, that's my takeaway at the end of this. If you take a copy of the Constitution, take it home, and please read it. This version has a lot of interesting material as well as the Constitution, and it might be a useful exercise for you, I think it would be, actually to read the Declaration of Independence first, which is also in this little pamphlet. That is, after all, the prequel to the Constitution. There's the intervening Articles of Confederation that didn't work and had to be discarded. Now, the Articles of Confederation failed because the sovereign states were very jealous about what powers they would cede to a new central government, not in London, but a new central government in the United States. And the result was a government that did not have the power to tax, that did not have the power to conscript or support an army or navy, that was impeded, and its economy impeded by the fact that each of these states put up trade barriers. A New Hampshireman couldn't fish in the waters of Massachusetts and vice versa. They each issued their own currency, chartered their own banks, which were failing right and left, is basically operated as jealously as one would expect them to do. But it didn't work. Britain was preying on our shipping. The government was incapable of defending the country, and the economy was in a terrible state when it was the unanimous and unavoidable conclusion that something had to be done and more powers had to be ceded to a central government. But the degree of power that would be ceded was the subject of great controversy. The proponents of the strong federal government, led by Hamilton and others, were the Federalists, Madison as well, Jefferson, Federalists, and the Anti-Federalists, who were extremely jealous of their state powers, George Mason being one of the most vocal, one of the signers of the Declaration, who actually didn't sign the Constitution because he said he left, he walked out and said he would rather cut off his right hand than sign that document, and worked tirelessly thereafter to modify the powers that had been granted to the federal government. In fact, the ratification almost failed because of the grant of powers to the federal government without any corresponding Bill of Rights. The idea in the enumeration of specific powers granted to the federal government and to the Congress in particular was that anything that was not enumerated was not ceded to the Congress. It's a simple concept. There they are in Article 1, Section 8, and some of the others listed one after the other. Issuing patents, creating money, raising an army, and so on. And there was no real reason to think that that would not be an adequate, well, there was as it turned out, but logically it seemed there was no need to do anything more than limit the powers that were being ceded to the national government. But that was not sufficient for the populace who were jealous of their liberties and afraid that the national government would start consuming their liberties, start expanding and doing things that were not enumerated. And so the sentiment was for a Bill of Rights to be added. And the failure to add a Bill of Rights or include a Bill of Rights in the original Constitution, as I say, imperiled its ratification. About 4 states had ratified the Constitution when the matter came up at the Massachusetts Convention for ratification. Governor, well, he'll come back to me. Governor was in the chair, and when it was clear that the Constitution was going to fail of approval in Massachusetts, he suggested that they ratify it on the understanding that a Bill of Rights would be added by the first Congress. That formula got it through Massachusetts and the rest of the states, 3 or 4 more that were necessary for ratification. 9 of the states were required by the terms of the document before the Constitution could come into force. And only 12 did ratify it until much later, the 13th state. Now, that Bill of Rights had been a matter of a great deal of consternation and discussion before the decision was made that it would not be in the original Constitution. The concern was that if one enumerated rights, that would give rise to a negative implication that anything not enumerated did not exist as our rights. And this debate goes back to London, to England, before our Constitution was being drafted, and the literature that we have on it has almost parodic examples. I have the right to marry or not marry, to wear a hat or not wear a hat, and that we can't possibly enumerate all of those rights. It's a fool's errand, and at worst will give rise to that negative implication that no other rights exist. Madison was of that view, and he ran for the first Congress, and he was gerrymandered into an anti-federalist district in Virginia. And so he changed his tune and said, oh yes, we need a Bill of Rights. We have to have a Bill of Rights. He wrote a letter to Jefferson, who was off to Paris, and said, I think it will do no harm, and if it does, and if it causes the people to venerate the Constitution, it will do much good. Well, it turns out, in retrospect, that they were both right. It's almost the only thing most people know about the Constitution, the Bill of Rights. They might know specifically about the First Amendment, most likely do. but rarely they know much more than that. And it is what causes our public to venerate the Constitution. At the same time, it has become reasonably obvious that the Congress has expanded its authority well beyond the powers enumerated in the Constitution, and has done so with the acquiescence of the Supreme Court. The provision allowing the Congress, or empowering the Congress to pass laws for the general welfare, became the predicate for being able to do things that were neither general nor welfare, that were specific. The general welfare meant for the good of the country, the whole country. And in the very first Congress, when Baltimore suffered a ruinous storm and there was a great deal of damage, there was a bill for the relief of the citizens of Baltimore, appropriating money for the benefit of that special group that did not represent the general welfare. And we are often running from there. Now we have earmarks and all manner of specific appropriations coming out of Washington. Madison got elected. He made it his solemn business to draft a Bill of Rights, and he asked the public to submit what they wanted, what they suggested be in that Bill of Rights. He got a lot of suggestions. The Anti-Federalists made their suggestions: no standing army, return the jurisdiction over the navigable rivers to the respective states, which had been apportioned to the national government, and so on. He culled the list that he was given, or the submissions, to a group of 12, and found it difficult to get floor time in the House. The members were not interested in this amendment to the Constitution, or these 12 amendments that he proposed. He did finally get floor time, and he walked it over to the Senate, and similarly found a great deal of indifference there, and eventually got it through the Senate and out to the states for ratification. When it was ratified in 1789, well, I should say I mentioned 12. 2 of them were never ratified. Well, I shouldn't say that. Were not ratified then. 10 of them were ratified, what we now call the Bill of Rights. By the way, it wasn't called that until around the 1850s, and primarily after the Civil War. And they were ratified, and the church bells did not ring. There was yesterday's issue, just as it had been in the Congress. Indeed, there was virtually no litigation arising from the Bill of Rights for a long time. To give you an example of the peculiar nature of the situation then, the Constitution provides in the First Amendment that the Congress shall make no law, as you know, abridging the freedom of the speech or of the press, or establishing a religion. Well, the states had established religions, several of them, Virginia, Massachusetts, I think Connecticut. They had long established religions. The Church of England had become the Episcopal Church in Virginia. And by established, I mean it was supported with tax money. Everyone was taxed to support the established church. Attendance was not compulsory by any means, but we had an established church. It's just that the Congress wasn't authorized to do anything by way of establishing a religion. And that sort of represented the relationship between the states and the central government at in these early years of the Republic. The states still went about their business as they had much before. And then that started to change. The ratification of the 10 meant 2 were not ratified. And what we now have is the 27th Amendment would have been one of those, was one in the original 13. And it provided, and still provides as the 27th Amendment, that no increase in the compensation of the members of Congress could become effective until after the next election. It was a safeguard then in order to make sure that the people approved of the members before they gave them a pay raise. And there was a student, I forgot, I think it was University of Texas, I'm not sure. There was a student who uncovered this historical factoid and decided to start a campaign to get the amendment passed, ratified. And indeed, the requisite 38 states or more, but the minimum being 38 now, 3/4 of the 50, did ratify the amendment, and it became our 27th amendment. That led this was 207 years after it was proposed. And that led the Congress to decide that it might be more prudent to put a time limit on the ratification of any future amendments, and they did so. So when the Equal Rights Amendment was passed by both houses of Congress and put out for ratification by the states, the time limit for ratification was 7 years. And it did not achieve the 38 necessary states ratifying it by the expiration of those 7 years. Meanwhile, some states that had ratified it, when the political situation changed, rescinded their ratification. And other states that had not ratified it during the 7 years went ahead and ratified it anyway. And indeed, Virginia, when Governor Northam came in before the current Governor Youngkin, got the state House and both houses of the state legislature to ratify the Equal Rights Amendment, which would have given it the 38th vote. Justice Ginsburg was asked about this situation. She said, well, it wouldn't make any sense to count the late ratifiers if we didn't also count those who rescinded their ratification. So then we'd be back down well below the 38 threshold. And it never got litigated. There just wasn't any real case for saying that that was valid, even though the Congress had specified 7 years. We've had an a balanced budget amendment that has had a lot of political momentum behind it at various times. Has never achieved even ratification by both houses. But it remains a favorite for people who are to propose that, knowing that it's pretty much hopeless. If our budget this year were balanced, we would be having to cut $1.7 trillion out of the federal government's budget, and you cannot cut debt service, should not cut the military. It would have meant everything else pretty much got cut, including transfer programs. Okay, now, today, there are proposals, non-trivial proposals that have been circulating to amend the Constitution in some respects. One of them is to abolish the Electoral College. Well, why have an Electoral College? Indeed, how does Electoral College work? Most of you probably know, because every 4 years we hear about the Electoral College, and we go and we vote for the electors who we want to send to the Capitol to cast their votes. And of course, in 2020, that became highly problematic, or not that controversial, I should say. Well, we have an Electoral College so that, going back into the original time period, so that Pennsylvania and New York or Virginia and North Carolina would not control the outcome of the election every 4 years. We don't have a national election. We have 51 local elections, state and DC elections. It's very hard to steal 51 elections, and I know we've had a lot of publicity about attempts, but it doesn't happen very readily. The framers equated democracy with mobocracy. What is the demos? It's the public. It's everybody, the demos. And if everybody is in the ruling class or the rulers, then it's no better than a mob. That was their view. And so They did not create a democracy. They created a republic and guaranteed or required that every state have a republican form of government. Many of you know that when Ben Franklin left the Constitution Hall on the last day when the Constitution had been approved by the Continental Congress, he was asked, supposedly, no one knows for certain, Dr. Franklin, what have you given us? And he said, a republic, if you can keep it. This had never been done, an extended republic. Venice was a republic. The Netherlands had been a republic. They lasted for hundreds of years as successful city-states, or in the case of the Netherlands, larger. But an extended republic was a new idea. Rome was not a republic of any real sort for any length of time. But they thought was, well, because it's an extended republic, and we had a whole continent of barren land, basically, that would eventually, most of it, we thought, and now all of it, be consumed by states. Because it's an extended republic, there will be a great number of different interest groups, factions they called them. And the factions would oppose each other and would prevent the emergence of a democracy by having these 51 different elections. And the states would oppose each other. Some would vote one way, some would vote another. They didn't have political parties, although they emerged almost immediately. And that would mitigate the danger of mobocracy. Well, suppose we eliminated the Electoral College now. What would happen? A small number of states with a large population would be able to determine the outcome of every quadrennial election for president and vice president. The arithmetic is clear. And in today's political climate, it's also something that's realistic. It could be that the eastern seaboard states and the west coast states by themselves would be able to command a majority in a general election. Italy has a general election. They've had 67 governments since the Second World War. It's not a prescription for stability. Now, nonetheless, what's happening is that some states are providing, in order to get closer to an abolition of the Electoral College, are providing that their delegates, or their electors, pardon me, that their electors must each pledge to vote the way the majority in the state voted. So instead of California's 52 electoral votes being distributed to however many to each candidate in proportion to their votes, they would all be given to the highest vote getter in the state. California has not done that. That's an example. Colorado, I believe, has, and a few other states. So there's clearly a sentiment to change this system. And being here not on the East Coast and not on the West Coast, treat this as a warning. That is, this may be lapping at your shores. Okay, so other things that are in the air to amend the Constitution. I'm trying to think what's current now, the balanced budget sort of quiescent. Anybody can remind me of another one that's kicking around or is popular here?
States.
Pardon me?
Convention of the States.
A convention of the states, right. So the idea that the Constitution provides that it may be amended by the process I've described, the House and Senate ratifying an amendment by 2/3 and 3/4 of the states approving it, or a convention could be called. A convention which in principle would have the same authority that the original Constitutional Convention had. That original Constitutional Convention was called to amend the Articles of Confederation. And almost the first thing that the members did was decide to put aside the Articles altogether and start over. And that could happen again if we had another convention. Now again, there's some safeguards that are being devised, I'd say not yet fully ready, thought through, but they're well along, to try to bind the delegates to a constitutional convention in such a way that they would not be able to do that. But whether a state limitation on what a delegate could do would itself be constitutional when that delegate gets to a constitutional convention is an open question. And the only precedent we have is that there would be no limits on what they could do. You can treat the Constitution as an amendment to the Articles. What would, in procedure, in Robert's Rules of Orders, would probably be called an amendment in the nature of a substitute. And that's what we could be looking at if we had a constitutional convention. Again, all right, I think I've probably tried your patience enough. And I like answering questions, particularly from an audience, because then I know at least one person is interested in what I'm going to say. But in this case, I will be interrogated professionally by someone whose mandate is to elicit something that you will be interested in. That will be his challenge. And so I'll cede the floor to the professor. So, thank you.
As they get situated, I'm going to grant myself the distinct pleasure of introducing Dr. Howard Wall. He, along with notable faculty, drew me into the magic of the Hammond Institute. Dr. Wall is an impressive economist with an intensive record of academic research and impact studies. I and others have become better economists and faculty and educators because of him. He is well known around the United States for his quick wit and humor. So check out his bio online. Howard, thank you for joining us, and take it over.
Thanks.
I have one footnote.
You have one footnote?
One footnote.
A footnote already, okay.
The governor of Massachusetts, who was chairing the Massachusetts ratifying convention, was John Hancock, without whom we would probably have no constitution.
All right, well, thank you for joining us today. And
Pleasure.
I do have a series of questions that people sent in, so there should be people that are interested, at least one person.
At least one, yeah.
And some of them I made up myself, so, you know, it
Well,
could just be me.
Especially satisfied then.
And I'm not a constitutional expert. I'm an economist, so I think I'm an expert in everything, but I'm a hobbyist, a constitutional hobbyist, we'll call it.
We all should be.
Which all of us should be. So let me first ask you a question. If, you know, based on what you were talking about, you know, so, and this is from Howard of St. Charles. Imagine that the founding fathers were brought back to life and saw what their work had wrought since 1789, so where we are today. You know, do you think they would make any dramatic changes to kind of the basic framework, or any specific thing might have made things go on the path that they would have preferred, or would they say, well, this is sort of where we thought things
No, I
might
think
go?
they would, it would be very difficult to convince them that what we have now, we have under the original Constitution.
They might not even recognize.
I think they would deny it and abjure it, saying this is not at all what we had in mind.
Oh, you're kidding me. This can't be this.
Oh, look, we have a federal government with almost plenary authority. And where the Congress has not legislated in order to extend its governance into local affairs like education and health, it has appropriated to accomplish the same thing by handing out money with conditions attached. So one way or the other, they've managed to do exactly what was meant to be prohibited.
Now, is there anything that would have, you think, or if you think the founders would have said, well, if we had just done this, maybe we would have slowed it down, or it would have turned out a little bit better? Or is it was just inevitable?
Well, you know, time marches on, things change. Some things changed legitimately with the amendment to the Constitution through the process. The authorization of a federal income tax, for instance. The federal government used to live on import duties. The federal income tax, the first one was unconstitutional because it wasn't, as required by the Constitution then, apportioned among the states. And so another one was, pardon me, so the Constitution was amended to allow, specifically to authorize the Congress to pass an income tax. And that was possible because the income tax was going to be 1%. This wasn't in the Constitution amendment, but in the understanding, the income tax would be 1% and would be levied only on people with a relatively high income. Well, here we are. It was 92 or 90% for a while in the 1940s and early 50s. Which even now is above what economists tell us would be the point where it inhibits, below which it would not inhibit economic growth, but it's now at a point where it does. And all in all, with state and local taxation, about 54% of the national product is taxed away by the federal and state governments together.
So along these lines, the expansion of kind of federal power over the states, have a question which I got a good explanation that came with it, if I could find it. I think this was Kurt from St. Charles, Lake St. Louis. So many government overreach issues can be traced back to a pair of Supreme Court decisions in the 40s, United States v. Darby and Wickard v. Filburn, that effectively erased the distinction between interstate and intrastate commerce and allowed all manner of federal intervention into areas that had been the purview of states. So that's correct,
Yeah,
right?
well, sure. The Article 1, which lists the powers of the Congress, it describes its composition as well as then enumerating its powers. And Article 1, Section 8, which does that, authorizes the Congress to regulate commerce among the several states, the Indian tribes, and foreign nations. It's absolutely clear that commerce meant trade. Trade among the states, for instance, trade with foreign nations.
Right, trade between among the states.
Yeah, well, I wish that'd be a big change. Yeah. So the result was that this was not controversial for a long, long time until the 1930s, and the result was that the federal government, the Congress, had no regulatory authority over things that were not interstate trade, such as mining, manufacturing, retailing, agriculture, much of the economy. What they could regulate were things that were moving in interstate trade and the instrumentalities of interstate trade, like ports and railroads. And under the pressure of the New Deal, when the Congress was continually passing laws at the request of the Roosevelt administration to do something that wasn't within that understanding of trade and of the interstate commerce power, they would predicate the statute expressly on the interstate commerce power, and the court would say, well, this exceeds the power, it's unconstitutional. And in the Wickard against Filburn, which involved grain, a farmer's grain, which was not going, it was grown locally and it wasn't going to travel interstate, was at issue, and the court changed its view and held that anything that affected interstate trade was actually within the power of the Congress to regulate.
I think he was even growing it for himself.
Could well be. I don't remember that, but that makes a lot of sense. So what doesn't affect interstate trade? Not a lot. There was a case coming out of Los Angeles some few decades ago in which the National Labor Relations Board had asserted jurisdiction to oversee a union election for a company that cleaned office buildings in central Los Angeles. And the argument was that the mops and the detergents that they used had moved in interstate commerce. The Supreme Court said no, that was not interstate commerce, but that could be a question that would go to the Supreme Court. Tells you how close it is to everything. There was a case called Lopez, U.S. against Lopez, probably 25 years ago, in which a man in Texas was convicted of possessing a firearm within 1,000 feet of a school, federal crime. And he had a public defender, and the public defender, I don't know if he was so creative and imaginative or naive, argued in his defense that he couldn't be convicted because there was no claim of interstate trade. Because, contrary to the usual practice, the U.S. attorney had not alleged that the gun had moved to interstate commerce, which it surely had. Guns are not manufactured in Texas. They're manufactured mostly in Connecticut. But they did not put that in. So there was no federal jurisdiction. Again, a fluke. Back to the...
So normally, that is behind every federal charge. They say, oh, and by the way, it's...
Well, there's some, well, not every charge, but every commercial case, like, I mean, thing that involves regulation of something, I'm trying to think what would not. Well, ordinary crimes, possession of a gun by a convicted felon, you don't have to prove the gun moved in I don't think you do, actually, I'm not positive.
Okay.
Maybe you do. It certainly couldn't hurt to put it into the complaint, the charge. Back to the 30s then for a moment. This changed everything. And there was a 1933 statute called the National Industrial Recovery Act. In 1933, when Roosevelt became president, the country was in an absolutely desperate condition economically. And Roosevelt, who was not a man of any firm convictions about economics, or any convictions at all, was open to all kinds of ideas, and indeed experimented with a variety of different things over the next several years. The National Industrial Recovery Act in '33 provided that every industry would be governed by a code of fair competition, two words that don't fit in the same lexicon, to be drafted by a tripartite committee with representatives of labor, employers, and government. Where'd this idea come from? Mussolini, corporatism. That's how Italy was organized at that time. And in the, I can't give it to you in Italian, but if I recall in English, it's nothing outside the state, nothing against the state, and a third one like that. I mean, it was meant to take over the entire economy in detail. And in 1935, when the Schechter Brothers poultry store in Brooklyn was subject to a criminal charge for having cheated on the minimum price by selling 2 or 3 turkey legs for the price of 2 or something like that, the Supreme Court said the whole statute was unconstitutional. It delegated the authority of the Congress to private individuals, basically, and Justice Cardozo, in his concurring opinion, said it was delegation running riot. Unanimous opinion. No, is that right? Yes, unanimous opinion. Now, one of the titles in the National Industrial Recovery Act had been the first National Labor Relations Act. And because there was no severability provision, it went down when the NIRA went down. So the administration wanted to revive and give another National Labor Relations Act. And Frances Perkins, who was the Secretary of Labor, said that she was at a reception in Washington speaking to somebody from the White House, somebody close to the president, when one of the justices of the Supreme Court walked along behind them, heard what they were talking about. They were trying to decide how to predicate the power. They were thinking the Commerce Act, I mean the Commerce power or the taxing power. And the justice supposedly said, with a mouthful of appetizers, commerce power, my dear, the commerce power. So that's what they did. And that came before the court on April 1st, 1937, in the Jones and Laughlin Steel case. And that was the end of the commerce power's narrowest interpretation. Rickard took it even further, the grain case.
So I know that over the last few years, you've really dedicated a lot of time to educating the public about the Constitution. You have PBS trying. You have a PBS series, and you have programming that you're working with to try to get into schools.
Right.
And so I take it that you see a general lack of constitutional knowledge.
We are in a desperate situation, and it is getting worse. Since 1972, the number of, or the percentage of high school students who have ever been exposed to, even before that, a civics class, has plummeted from about 80% to 20-some. The diagram going from 72 to 2000 is just like a ski slope, and then it drops off a cliff then because, I think because of the No Child Left Behind Act, which said, hey, school districts, here's federal money for teaching better, doing better on math and reading. And so art, music, civics, out the window. So now it's the exception. I mean, the good high schools in the big, wealthy suburbs are doing it. But it is the exception rather than the rule. And the states, if you go look on this, one of these social science web pages, I can't tell you which one it was, it lists every state and what they say is required for civics. 1 semester or 2. And they all say 1 or 2. They're all lying. Well, they're just left up there what was maybe true a long time ago. Because basically they said to the American history teacher, you cover it. Cover civics while you're at it. Or maybe the government teacher. They still have exposure to a government course in majority of the schools. Here's how bad it is. Because of what I've just described, every year the graduates of high school are more ignorant than their predecessors. 48% of the people cannot name the 3 branches of government. 22% cannot name even one, which is pretty pathetic and dangerous. 45% of the people believe that an alien in the United States has no rights whatsoever. That's dangerous, and given their political situation today, it's really dangerous for the people who are here, many of them illegally, but this is just people who are not citizens, so they have no rights, including those who are here lawfully, several million. And these people vote. They grow up, they get older, and they actually vote. They don't know anything, and they can be led astray. One of the political candidates now seeking the Republican nomination goes around promising to do things that are unconstitutional, or that would require the approval of both houses of the Congress, and to do them on day one. And even the press doesn't question them.
So on the topic of ignorance of the Constitution, in April of 2021, President Biden, in referring to the Bill of Rights, said that no amendment to the Constitution is absolute. You can't yell fire in a crowded movie theater and call it freedom of speech. So I have 2 questions about this quote. First, I know that the part about shouting fire in a crowded theater is complete bunk. Can you explain why it is bunk and how it is that so many people, including the President of the United States, who has a law degree and at various times claims to be a top in his class, get it wrong? And secondly, can you comment on the claim that none of the individual rights listed in the Bill of Rights is absolute?
Well, that's true. The Supreme Court has said not that broadly, but with each one in particular has said is not absolute.
But it's not carte blanche.
Oh, no. But there are things that fit within the terms of the amendments in the Bill of Rights that would be particularly unreasonable to protect. Okay, the easy example is the Second Amendment. Right now, in the Heller case, the court said, well, the Second Amendment was meant to protect people's ability to retain weapons for self-defense and hunting, putting food on the table, which at the time was a large portion of the population. As opposed to saying, since it begins by saying something I'm going to have to, well, it's right here, isn't it? The necessity or what have you of a well-regulated militia being important to the security of the country, that there's this right to keep and bear arms. And the court said, well, it's not there, and this is actually good grammar. That introductory clause doesn't narrow or limit what follows as a matter of grammar. It's come up again in the provision in the Constitution that says that in order to advance the sciences and the arts, the Congress may authorize the issuance of patents and copyrights. Well, that doesn't mean patents and copyrights can be issued only if they show that they're advancing the arts in some way. And the court said, you know, that's just not a limitation.
That's the argument of gun rights. When people want to regulate guns is that it's only about the militia. Whereas the militia was just saying...
But the Supreme Court has rejected that.
Says, yes,
yeah.
you have a right because of this other thing, but the right is not predicated on it.
And it's not absolute.
Right.
So today there are arms that couldn't have been imagined at the time that it would be very unwise to see in private hands, considering some of the things that go on even with guns of a reasonable size. And so to allow people to carry anti-aircraft guns and surface-to-air missiles around would not make sense. So you know, now on the quartering of troops in your home in the Third Amendment, I don't think there's any learning. I don't think there's been any cases on that.
Well, Wikipedia says there have been no
Oh, really?
cases.
So can the government quarter just a few troops in your home? I don't think so.
Well, there was a case a few years ago where someone sued, I think, Nevada, because Nevada had put police officers in their house as a stakeout.
Oh.
And something happened, and they sued on the grounds of the Third Amendment that this was quartering troops, and I believe they lost.
Yeah, I would think so. But the flip side of this is applying the words of the liberties protected in the Bill of Rights to situations that couldn't have been imagined before. And that we can't allow to be sacrificed simply because of a change in technology. And people think that, oh, well, this is a big challenge, but it's not really. There are principles underlying these provisions that can be brought to shed light on, brought out to illuminate their application to new situations. So now the police, there was a case about 20 years ago in which a police department, police cruiser rode up and down the street using a heat detecting gun, which is a laser, I think, to identify houses in which there was a big concentration of heat, a kind associated with growing marijuana in someone's home. And the question was, well, since a search or seizure requires a warrant, did doing this require a warrant? And the answer was yes. Just because the government or the police can penetrate your wall doesn't mean you don't still have a wall, right? It is your premises, and it's protected against intrusion by clever means as well as traditional ones. Right? The principle is there. Justice Scalia authored that opinion, as he did the gun opinion.
Well, and like with the gun debate, I hear people say, where does it say in the Constitution you can have an AK-47?
Yeah.
The answer is right where it says you can only have a musket. Right? So
well, more or less, yeah.
Neither
yeah,
one is in there, it's arms.
That's right.
Right.
That's right. And in the opinion that Scalia wrote in Heller itself, that font of all this, because now there have been several cases, he said, in addition, restraints that have been imposed traditionally over the years on the possession of a gun, reasonable restraints are not imperiled by this. So keeping guns from children and from maniacs is still a reasonable exercise of the police power.
And regulation of automatic weapons.
Yeah, there are, the lines start to get difficult, but basically the way the cases have sorted out, I think, is that a cartridge, pardon me, I forgot the term. If you have 10 or up to 14 cartridges, I think it's regarded as untouchable. Yeah. But these 30 what's the word I want that holds all the bullets?
So the 30 The 30 bullet magazines.
Magazine, thank you.
Yeah.
Right. Can be regulated by the state or prohibited by the state. In D.C., I had a case involving, D.C. had a very strict, basically made it impossible for anyone to have a weapon at home until Heller came along. It came from D.C. actually. And then when they lost that, they erected another set of barriers, about 15 of them or so, and I was on the panel in the court that reviewed that. And some of them were clearly just meant to inhibit gun ownership. You know, reporting every 3 years and your change of address, which you had to do anyway to the government. Various qualifications that were difficult to meet. On the other hand, they had an eye test that you needed to pass just to drive a car. It's not that silly, right?
Yeah.
So that was upheld.
So changing the topic a little bit, although I guess it's still the Constitution. So this is from Joe of Troy. The court seems to have altered its interpretations regarding religion from being anti-religion to being neutral towards religions. So there was a Missouri case of state funding for school playgrounds a few years ago, and then there was a recent case in Maine that struck down their ban on public funds for religious schools for vouchers in rural areas.
Right.
So it seems that this is like a turn, but back towards what the original
Yes, I think
intention
so.
was.
I think so. I think it was Jefferson who authored that troublesome phrase of a wall of separation between the church and state, which was when you get to a later time in history when governments are handing out subsidies, that doesn't work. That's because that to say, well, they can't contribute to the support of the sectarian school in the way it would to the government school is just to be hostile to religion instead of neutral. So, I mean, why do we have government schools, by the way? Anybody? I mean, the first one was compulsory government schooling was in 1847 in Massachusetts. It was a disaster. The rationale that you'll hear is so that we have an entirely literate population, that everybody gets an education of at least some sort, although that's, whether we're achieving that now is questionable. But that's a reason for public financing of education, not for the public provision of education.
Well, wasn't it a big motive was because the Catholic Church was educating too many people, so we needed to prevent them from educating too many.
Well, in the 1850s, the immigrants, huge influx of immigrants, mostly from Ireland, also Italy, all Catholic, almost all Catholic, had created a huge blight. These were largely illiterate, agrarian people fleeing a desperate situation with the failure of the crops in Ireland, who were ill-suited to urban life in Brooklyn and in New York. And prostitution and drunkenness and all manner of corruption was rampant. And the cardinal, and his name I've forgotten now, the cardinal in the 1850s built that school system. And it was larger than any public school system at the time. A fantastic accomplishment. And of course, it's being whittled away at now.
Had to be stopped.
Well, it's economically diminished. I mean, getting nuns and priests and so on to teach is.
Oh, you'll see articles in our local paper, one saying, oh, all these Catholic churches are shutting down, and others saying, voucher threatens public schools. And not really seeing that
competition
these are the same
threatens public schools. It does.
Yeah,
right?
exactly.
Any competition against a monopoly is a threat. And they don't have a legal monopoly because we do have charter schools, and at least in some states, and private schools everywhere. But they have a de facto monopoly by virtue of public support that doesn't, so they don't have to charge tuition. Their ubiquity. Now in some places we've seen it happen. It's not as quick as I would have hoped, where the charter schools and the homeschoolers and so on become numerous enough that the public schools pull up their socks and actually improve. And I'm hopeful that we'll see a lot more of that with more competition.
So this is from Diane in University City, which is close by. I'm not a lawyer or a judge, but I can tell that politicians and pundits commonly misrepresent or misunderstand some very basic things about Supreme Court cases and decisions. I think we talked about this on the phone.
Yeah.
And it angers me, so it must really get your goat. Which recent cases do you think are most often misrepresented or misunderstood, and why? Is it just politics, or do people really not understand things very well?
Well, it's both. In the media, the presentation is very biased, starting with identifying every Supreme Court decision author by reference to what president or what party president appointed him or her. And I understand that the public, has an appetite for that, but it exaggerates something that's really of insignificance and should be. I think the best coverage of the court is in the Wall Street Journal, and even there was recently I think a terrible mistake. It wasn't about it was about a specific case, but the publisher or editor, I forget what it is, Gerard Baker, who writes a column once a week, and it's excellent. And he referred to 3 recent cases from last term in the Supreme Court. The let's see, they were the affirmative action admissions to colleges case, the West Virginia case in which the court said that the EPA could not reorganize the entire energy industry of the country without a more clear authorization from the Congress, and the president's proposal to write off $400-some-odd billion of student debt. And he referred to this as the court returning to and expressing American ideals. Well, that's fair enough with the admissions case in terms of race neutrality. It's fair enough with regard to the West Virginia case and saying that the EPA shouldn't be able to do anything without some legacy that it can trace back to the Congress authorizing it. It doesn't have any power unless the Congress gives it. But the student debt case was just a statutory interpretation. It wasn't even a constitutional case. You read the statute and come to a decision on what it means, what it allows. So I thought that was unfortunate, but otherwise they have, I think, a very good record. So then you get this politicization of, of attributing the author of the opinion to a party. And then the other is just the paucity of explanation. The vast majority of people, I would say today, if they've heard of Citizens United, don't understand it. This enables corporate and union contributions to political races. And it is difficult to explain.
It's first said that, it gives the free speech rights to corporations that never happened before.
Right,
or
right, all of that.
All sorts of things.
Yeah. Right.
Yeah. So is...
But, if you and I create a partnership, we don't surrender our free speech rights.
Right.
Right, and our contribution since Buckley against Vallejo in the 70s is a form of free speech. And if we form a corporation, we don't give away our freedom of speech to do it. Yeah.
And that was now I forget, what's the religion and Obamacare case?
Yeah.
We're going to be up here all day trying to remember that.
I'm sorry.
Hobby Lobby.
Yeah, right.
So the Hobby Lobby case was exactly that.
Yes, that's
that
right.
When you have a close corporation of 5 related people,
right,
you don't give up your religious rights.
To decide not to hire somebody who disagrees with you or undermines your enterprise.
Right. Now, can you explain a recent case that also is misunderstood or misinterpreted is the creative case?
Oh, yeah. So Colorado has a Human Rights Act. Most of the states now do, which takes what is modeled on Title VII of the 1964 Civil Rights Act provision, the public accommodations provisions, that prohibits discrimination in public accommodations broadly conceived, that is to say hotels, restaurants, but also retail establishments, on not just the original grounds, which were race create religion, or 3 or 4, and then sex. But in Colorado, also on gender identity, I think they call it. In any event, it was meant to protect, confer the same protection against discrimination on gays and so on. And this woman had a company called 303 Creative. I think it was just herself, but I'm not sure.
Yeah.
And she did web designs. You create a web page for you. And this gay couple who were getting married under Colorado law wanted her to create a web page. Oh, actually, pardon me, that hadn't happened yet. She was concerned, this is a criminal penalty, or a fine associated with civil or criminal, but a fine associated with violating this provision. And she was concerned that she would be compelled to create a website for a gay marriage that she opposed in principle, religious principle. And so she sued for a declaratory judgment in federal court, I think, that the law could not constitutionally be applied against her if she declined to provide that service for a gay marriage. And her argument was that this is speech. I'm creating something. Indeed, she typically wrote a poem for the occasion, and that her speech couldn't be hijacked by the government to do something that she didn't want to support. And Colorado had 2 arguments, the first of which was that, well, it hasn't happened yet, so she shouldn't be able to challenge it, and doesn't have standing, but the court rejected that handily. And then secondly, that, well, it isn't really speech. But peculiarly, the state had entered into a stipulation that said it was, quote, pure speech. So once they did that, I don't see, they had no chance at all of then winning on the ground that it wasn't really speech. So.
Well, in that case, it was often misrepresented as a religion versus gay rights, when it was really speech.
Yeah, it is a speech case, that's right.
Yeah. So, a few more questions. So you've been a judge for how long?
In November will be 37 years.
37 years. So we have... We can get you more applause for how long you've been married. I don't know how long it is.
Justice Marshall was asked how long it's a lifetime appointment or sentence, if you like, how long he intended to serve. And he said, I intend to serve out my term. As do I.
So in these many years, you must have started really, really young.
I was 40.
Yeah. So this is a question from the Village Duchesne High School, Chris Livingston's government class. So what case have you presided over that fulfilled you the most, personally or professionally?
Gee. In my court, unlike any other federal court, most of our work involves challenges to government action. Whether it's an adjudication by some government official who makes a decision, or the issuance of a regulation by a government agency that is then challenged in the Court of Appeals. And so it's a pretty bloodless scene. There are only 600,000 people in the District of Columbia, and most of them don't have any federal cases that would come up for them. And so we very rarely get cases in which there are actually individuals represented. About 7%, I think, of our cases are private civil cases, whereas that would be probably 40 or 50% in the other courts of appeals. 90+% of our cases have the government in them. Maybe 10% are government criminal cases that they've brought, and the rest are cases against the government, challenging a regulation, challenging a decision, disappointed government contractor, an employee suing for Title VII discrimination in being discharged or what have you. There's actually a real person in that one, but there's only lawyers in the courtroom. I mean, the public's allowed, the clients are allowed, but in fact, there's hardly anybody there usually. So it's very much an academic enterprise inquiring into what the law means as applied to the situation in front of us. The biggest case, the most interesting case, the case in which I've got the greatest satisfaction, I think, is still the 2001 Microsoft decision. Just to give you a sense of it, the record in the court was 10,000 pages. Microsoft digitized it for us, but at that stage of development, they couldn't digitize the exhibits. All the graphical exhibits were on paper. It was just chock full of interesting antitrust issues in particular, trade issues, and the whole court worked on it for 6 months. I had one of my law clerks who didn't do anything else for 6 months, just helping me with that case. So it was a big piece of my career, and I still relish it.
Now, what ended up with that case?
Well,
I remember that it was dropped.
The government brought the case in our district court. Microsoft was held to have violated the antitrust laws in about a dozen, maybe more ways. The district judge, as a remedy, said that the company had to be broken up into two, one that would an applications business, and the other basically a Windows business.
Searches A through M and N through Z.
No, I didn't do that. But then it went on appeal. Several of the counts against the company were reversed. So if we went from, say, 12 to 6 or 7 ways in which it had violated the law, it had to go back for the district court to reconsider the remedy, since the situation was not as severe as the judge had thought. And then the administration, the Bush administration, came in 2001. That's when our decision was made, later that year, and settled the case. Instead of breaking the company up, they installed a monitor for 10 years inside the company with staff to prevent recurrence of the kinds of misbehavior that had been
like
proven. Well, the monitor was sort of the prisoner,
yeah.
Right? The 19 states and the District of Columbia who had joined the United States on the plaintiff side, all but Massachusetts and D.C. accepted that settlement. They appealed a second time and lost.
Oh, okay.
Yeah.
So here's a question. So how has the 10th Amendment held up? So let me read the 10th Amendment.
Sure.
It's not a long one.
Good idea.
The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people.
So I'm going to combine it with the 9th, okay? The 9th and 10th.
I have that on here too.
Okay, the 9th and 10th Amendments among the Bill of Rights, so-called, passed when the 12 were sent out to the states, were meant to nail down this situation, right? That 9th Amendment, the rights enumerated in the first 8 amendments are not the only rights you have. Right? In fact, you retain all of your rights except those that were, by virtue of anything delegated to the Congress. You want to read the 9th as well?
So the 9th Amendment is the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people.
Yeah. And then the 10th saying that the powers taken by the federal government are just what they say, limited to what they say, and everything else remains with the states or with the people respectively. Well,
I've seen in some researching for this, I was shocked. Maybe I shouldn't have been shocked.
There are a few 10th
academics
Amendment cases.
who have found the 9th Amendment in particular to have the opposite of the meaning used.
Well, the 9th Amendment has not really been litigated. The only reference, I believe, in all the Supreme Court ever is in a separate opinion by Justice Goldberg in the 60s. Let's see, wait a minute. It wasn't in Roe. I don't think it was. Anyway, it was in a very important case. But he's the only one who invoked the 9th Amendment. And then the 10th Amendment has been the source of some litigation and some learning. And one thing we know from the Supreme Court is that it prevents the federal government from, their word is, commandeering state resources. So the original case was one in which the federal government, Congress had passed a law requiring state officials to engage in I don't know what you call them, some kind of background checks when people purchased firearms. And this was actually not an insignificant burden on rural sheriffs. and went up to the Supreme Court and they said, governments cannot commandeer the state's resources like that. And there have been a few other cases of similar nature.
So this might be controversial. Well, it's a controversial topic. We'll see if I have a question that balances things. And you can answer whatever part of it you like, of course. So for all of my, this is from John of St. Louis. For all of my adult life, Roe v. Wade has seemed to dominate every aspect of national politics. For every judicial appointment, Senate election, and presidential election, the effect on Roe's survival had to be factored in. What do you think courts in particular would, or how do you think courts in particular would differ if Roe had never occurred and the abortion question had stayed with states and their legislatures in 1973?
Well, as we're seeing now, there would be a great variety of legislative responses and a very limited role for the courts to review those responses. There might be some state Supreme Courts that are aggressive and reading their own state constitution in some way that limits what the legislature has done. But bear in mind, and this was implicit in the question, until the spring of 1973, this had never been a federal issue. There was no law of any sort bearing on this. Every state had a law. The common law, which we inherited, the rule was that that an abortion was lawful until the fetus was quick, meaning kicking. Roughly the first trimester, I believe, is what that means. And then that got changed by the states in the mid-19th century, in many of the states, I should say, particularly the states where there was a large Catholic influence. Connecticut was a good example, but there were several states that altered the law to prohibit it altogether, or altogether with some kinds of exceptions we hear about now. When the court got the Roe case, it was coming from Texas. They had the most extreme case law possible, basically a blanket prohibition. And instead of, well, what they should have done, which is saying this is not a federal issue, but once they crossed that Rubicon, instead of saying, well, this is unconstitutional for whatever reason and striking it down, they imposed a standard that struck down every law in the country. Ruth Ginsburg, by the way, was very critical of that. She was in favor of the decision or of the idea, but not of what the court actually did. It was a terrible mistake. Now, there's a lovely study by a comparativist at Harvard Law School, a colleague of mine when I was there, who wrote a book called Abortion and Divorce in Western Law. It's a study of 23 countries. And in each of them, the law on those two subjects, abortion and divorce, had changed in recent times. As you can imagine, in 22 of those countries, the abortion law changed because the legislature changed it. And that was pretty much it. We don't hear about riots and political campaigns on this issue in the United Kingdom or in Germany.
Or Ireland recently even changed it by legislation.
Well, now it's being revisited. The law that was enacted in Ireland at the time, prior to the 70s, has been further liberalized more recently. And Italy is, I think, either has done or is likely to do that as well. Liberalized in the sense of more tolerance for abortion. But when a legislature makes a decision on an important matter, it inevitably requires compromise. This is an issue on which the public is divided, as we know. It's one on which people feel very strongly. And it's not a tiny minority position on either side. There's a very significant minority on each side. And when that happens in a legislature, there has to be a compromise. Nobody gets everything they want, or they get nothing at all. And so they compromise. And we treat that as legitimate. That's how we're represented. That's how the Constitution of our state is set up, just as it is for our national government. We may not like it, may want to change it further, and so on. And for a court to come along out of the blue and intrude itself, and it's the most significant aberration since Taney's decision in 1853 saying that African Americans could never become citizens and so on. You do not resolve a question like this by judicial fiat or by courts at all. That took a war.
Now, was this at the end of a series of kind of building?
No.
It was just, I mean, for the court to step in and try to solve social issues with its decisions?
Well, Roe versus Wade just came out of
just out of the blue.
Yeah, as far as I know, I don't think there was a lot of litigation trying to get the issue to the court.
Mm-hmm.
That has happened since then with other controversial issues, and the court was very obliging in opening its doors to lots of things. I mean, on gay marriage was another one.
Mm-hmm.
The states were deciding that. Iowa had said that the Equal Protection Clause of the Iowa Constitution, Supreme Court had said, and I think it was 5-2, that required recognition of gay marriages. Several of those judges were turned out at the next election. Ironically, not the author of the opinion. His term wasn't up at that time because the people wouldn't have it. That is a safeguard in the states that they can, as a practical matter, under extreme circumstances, and it should be under extreme circumstances, overrule by removing judges. In California in the 1960s, when Rose Bird was Chief Justice, the court held the federal Constitution made capital punishment unlawful, unconstitutional. The Supreme Court held that at one time and then reversed itself within a few years. The voters of California, by referendum, changed the Constitution. The court again held it unconstitutional, this time under the state constitution. At that point, they were thrown out by the people.
So, so I'm some number of years old, and
Can't remember.
Yeah, I can't remember. I'm that old. Whatever the age is where I can't remember it. And it seems like, through my adult life, the Supreme Court has been more discussed politically, if not political, but it's certainly, they're accused of being political. It's more rancor, there's more rancor discussing the Supreme Court, and it seems to be an upward trend in this. Is this a moment in history, or is this a common thing throughout the U.S. history?
No, it's periodic.
It's periodic.
Yeah. The last time, I would say, was in the 30s, when President Roosevelt led the campaign against the court. The four old men, or whatever it was, maybe it was more than that, four horsemen of the apocalypse, and proposed that because he couldn't get the New Deal legislation through, that the court be expanded with one new position for every judge then over the age of 70, which would have meant 4 new seats. It would have been a court of 13. There would have been a clear majority with his appointees on the court in favor of authorizing all of the proposals that the New Deal was coming up with. There were 96 senators at that time. More than 60 of them were President's Party, Democrat Party. It got 27 votes in the Senate. public wasn't having it. I don't know today. Probably wouldn't be that close. I mean, it'd probably be more close than it was then.
Closer, and President Biden has said he's not interested in it.
He's not interested in that. He set up a commission that was guaranteed not to make a recommendation like that. A large number, maybe a slight majority of the members had been clerks for justices on the Supreme Court. The others were responsible citizens, professors and so on, even if they hadn't clerked. That just wasn't in the cards. And they did make a bunch of suggestions, some of which are not in the least unreasonable, such as an 18-year term instead of a life term, amending the Constitution, provide an 18-year term. Every president, every 2 years, gets to appoint one of the justices, and if there's a death or resignation, then another one.
Right.
That's not a crazy thing. And we're, I think, the only country, certainly the only one in the West, that has lifetime appointments for judges.
My impression is only the ones that will never, like expand the court, that's the only one that ever gets talked about in the press.
Right,
These
right.
reasonable ones are tossed out.
Not interesting for the press.
Yeah, not really very interesting.
Right.
So I think we're out of time. I think we've about up to 8 o'clock almost.
You got any questions?
We managed to, well, I have one other question, but it's a really boring one, so it's not worth the extra.
Can we?
Now we can
You wanna take
open it up to the crowd a little bit if you like.
How much time do we have?
Oh, a few minutes.
Okay, well,
Now, there are two judges who are here who might,
at least. Maybe
Want
more.
to ask a
Who knows
question.
how many judges lurk in the audience?
yeah. So we have time for one question, so make it a good one. Okay.
Judge
So
Clark.
Judge Ginsburg,
First, identify yourself.
I'm Steve Clark. I'm the Chief Judge of the U.S. District Court of the Eastern District of Missouri. So administrative law, the administrative state, sometimes referred to as the fourth branch of government. So just context for this, if we look at the United States Code, United States statutes, they could probably all fit in a bookcase 5 feet tall, 4 feet wide. Maybe a little bigger now after some of the statutes passed in the last 14 years, but a definable, confinable amount of law passed by Congress over the lifetime of our country. The administrative state, however, regulations passed by federal agencies or enacted and promulgated by federal agencies would take up, by some estimates, many truckloads, many semi-trailer truckloads. They have the force of law. My question is this: what, if anything, in the Constitution expressly authorizes the administrative state that allows administrative agencies to enact regulations that have the effect of law?
Now,
So were you able to hear the question in the back? You did?
yes. Okay.
Okay,
yes,
great.
yes, okay. So now, Judge Clark, being a good lawyer, would not ask a question to which he didn't know the answer. He just wants me to tell you instead of himself. Well, first of all, the Code of Federal Regulations, I have it in my office, fills the cabinet from actually up to almost to the ceiling here, 1, 2, 3 of these panels wide. That's the Code of Federal Regulations. They're coming out at 60, 80,000 pages a year, something like that. There have been years where it's half again as much as that. So the Article 1, Section 1, would you open your constitutions, please? And if the congregation would read along with me, okay? I need a page number because I can't find where it begins. We've got a lot of things before the Constitution in here. 31, thank you. All right. Article 1, Section 1, all legislative powers herein granted, that's the enumeration, shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. Now, that put the legislative power in one place, and the Congress has, from time to time, and increasingly over the last several decades, delegated that power to another place. So, in small ways, this began very early in the Republic because it had to. There were matters of relatively small matters that just couldn't be legislated by the Congress all the time, on the collection of duties for, at the ports, on the postal service, and so on. And so that was thought of as just the executive power. If you create a postal service and you have a postmaster, the postmaster is an executive. He's got to be able to tell the subordinates what to do. And you can, when it's tiny, he can just talk to them personally. When it's larger, he's got to put out something in writing. But the first case, I think, is 1821, the Hampton, J.R. Hampton. And it goes along with very few bumps in the road, very few things being tested as unlawful delegations of authority from the Congress to an administrative agency, which is really the executive. And then in the 1920s, actually in 1914, the Wilson administration, which is a great proponent of delegation to experts. That was the idea. Experts would govern us, as opposed to politicians elected by the people. So we would have experts for the Federal Trade Commission, 5 positions, and it would be authorized to charge somebody with breaking the law, an executive function, hold a trial and decide whether they broke the law, a judicial function, and issue regulations with the force of law, a legislative function, so that if someone violated the regulation, they were also liable. So we have the separation of powers into these 3 articles, legislative, executive, and judicial, was totally collapsed into this one administrative agency exercising all 3. The Supreme Court upheld it in the 20s. Not only that, they were given a term of office, 5 or 7 years, I forget, I think it's 7 years, which meant the president could not fire them except for good cause. Now, the ability of the president to exercise the executive power and discharge somebody had been contested from day one. There's a 2-volume history of it called the Unitary Executive, starting with Washington, in every single administration up to Bush 1, which is where the authors stopped. And in the Civil War, the Congress the Republican-held Senate was going to legislate a term of office for Lincoln's generals. It took a long night at the White House for him to convince them not to shackle his authority this way. And it was probably almost certainly unconstitutional. So you have this combination now, an agency with delegated authority to do all these things, legislative, executive, judicial, and be immune from removal by the president, except for misconduct. So this has grown exponentially. I would say it's metastasized. And we now have scores of these agencies, probably 15 or 20 of them created just during the New Deal. So is it an undue delegation? Well, the court has said, they said, the unimportant matters, the policies have to be prescribed by the Congress, but the details can be filled in by the delegate, the executive agencies. Until 1943, when the NBC case, the Federal Communications Commission had been structured as it was, like the FTC in 1934. The challenge gets to its constitutionality in 1943, and on delegation grounds. And the court says, well, we've always said you have to have an intelligible principle for the delegate to follow. And in this case, what was the intelligible principle? It was regulate, quote, in the public interest, close quote. That was an intelligible principle. So obviously, no principle is required. They can delegate anything and everything. And increasingly, over the years, they have delegated authorities to these myriad agencies in broad terms and defying the expectation of the framers that the 3 branches would be jealous of their powers and would protect their powers against the other. The Congress has been ceding its powers to the executive as quickly as it can. Who's for clean air? I'm for clean air. Well, let's create an agency to get us clean air. So I tell my constituents I voted for clean air. Now, when they send a letter to a factory owner in my district saying we're going to close your factory because you can't meet these standards, he calls me and I said, oh, that's outrageous. I'll write a letter to the administrator of the Environmental Protection Agency. I get to claim credit for clean air and for helping a constituent, if at least trying to. Nothing can happen. Well, now in the last few years, there have been 4 cases in which an agency claimed such broad authority from an ambiguous or detail in its statute delegating its powers that the Congress had said, the Supreme Court has said, that's just not plausible. If the Congress had meant to give the FDA authority to regulate and therefore ban tobacco, they would have to say so. It couldn't be just hidden. As Scalia put it, the Congress doesn't hide elephants in mouse holes. But that's what the FDA was proposing. And recently in the West Virginia case just last term, West Virginia took a little provision in the Clean Air Act that had never been, it's been used a lot, but had never been read, to authorize it to require a plant, utility, to do something other than clean up its act on its site. And this required it to, if it was emitting more than some threshold amount of emissions, to offset that by buying another utility or doing something elsewhere to offset that, buying carbon credits, whatever. That was a bridge too far, totally unrelated to the delegation, and the court said so. So there's some hope that the court will rein them in.
Well, I think we'll end on the there is some hope. And thank you.
Thank you. Thank you.
We're just calling it.
Thank you. Thank you. Thank you, Charlie.
Thank you. Thank you so much. Thank you. Yeah, we've got, Matt, we need our gift baskets, and while they're bringing those up, or the bags, I want to ask all of you, did you know that all institutions receiving federal funding, including funding through the U.S. Department of Education, are required to hold an educational program pertaining to the United States Constitution this next week? You ask, how do we know that? Well, Walter Williams, the person in which we honor tonight with this memorial constitutional talk, shared that nugget with us. Please stay in contact. Let us help you empower the schools with the information that people need. We've got the Free to Choose Network, isit.org, with the Fundamentals Civics program. We have Stossel in the Classroom, the Center for Independent Thought. We have the Hammond Institute. We have lots of swag in the back of the room. We have coffee cups that we would like for you to take away. Please take your classical readings book, your Constitution. Take the test. Find out what you know about the democracy. Sometimes you'll be stunned, won't you? It's available free online. People are going to stay around. We have contests for the students. We have incentives for the educators. Help them empower the next generation. They are our caretakers. They're our doctors. They're our investors. They're our plumbers. They are going to be taking care of us in our old age. And with that, again, I want to thank both of you. We are honored, Judge, that you were here. Again, thanks to our sponsors, and most importantly, thanks to all of you. VIP guests, if you'd linger around, that would be great. And we conclude tonight's talk. Thank you, everyone.